A wonderful good morning to everyone. On behalf of the board and management and staff of exporTT IPO office, we want to welcome you to today's online training program on trademarks and the Madrid Protocol. Today we are joined with our facilitators, Kavish Seetahal, legal officer from the IP office, and Krishan Maharaj, manager, Capacity Building and Program Financing, exporTT Limited. Our key speaker, Kavish Seetahal, has been an attorney in Trinidad and Tobago since 2011. He has significant experience in intellectual property in both the private and public sectors. He's very passionate about issues of social justice and helping those who are marginalized in society. Kavish is currently pursuing a PhD researching poverty alleviation methods in various countries around the world. Our second speaker, Krishan Maharaj. Krishan Maharaj is the manager of Capacity Building and Program Financing Unit, exporTT. Today, he will present on access funding to secure intellectual property for your company and products. Ladies and gentlemen, to improve the quality of this webinar, we are asking persons to ensure that your videos remain disengaged and mics placed on mute for the duration of this session. Note all questions will be addressed during the designated Q&A session. However, feel free to place your questions during the session in the chat box addressed to everyone. Since we have an extremely large group of professionals, we encourage you also to use the raise hand option during the Q&A segment. You will be acknowledged and then allowed to unmute your microphone. So Kavish, over to you.
Thank you very much, Judy Marie. Thank you, exporTT, for collaborating with us and hosting this virtual seminar. Good morning, afternoon, evening, night, wherever you are in the world, whatever time zone you're in. Good day to you and welcome to this virtual seminar. Obviously, COVID-19 has brought its challenges, but also the opportunity for us to join in large numbers on virtual rooms. So here we are. I thank you all for joining us today, and I thank you all for your time. We have a great agenda this morning for you, and I hope that this would be as engaging as possible. I will try to field as many questions as I can in the allotted time. Obviously, right now we have 72 plus another few other people waiting. We might cross 100 persons in attendance today, which is awesome. But I may not be able to field all of your questions and all of your concerns. So if you need one-on-one sessions, there will be emails that you can email us at the TTIPO. Obviously, you could contact exporTT. Learn her name well. Her name is Judy Marie Rock. You know, she will provide you her personal cell number at some point, I presume. Judy, is that right? Yes, yeah, I'm sure. I'm sure she would be willing, ready, and able to do all that it takes to help you on your journey. And so, without further ado, good morning all, and let's begin. Just going to share screen here. Right, there we go. Okay, right. Sure. Right. Right, okay, so just give me one moment here. You know, technical difficulties and all. all that aside, Zoom is not allowing me to change my display settings. So just one quick moment up here. Right, this, oh, why am I not allowed? Why is it not allowing? Why is it not allowing me to show my display settings? Would you answer me that question, Zoom? Zoom, you are being difficult. Okay. Can you all see and hear? If you can't, drop a note in the chat box. If you have questions along the way, raise your hand. I'm a bit of a hollaback presenter, so if you need to ask something that's burning on your mind, I think the best way to learn is to get the questions off of your chest, and so that you can learn as quickly as possible, and we will work from there. Just give me one moment here. Okay, good morning, everyone. Welcome to Trademarks IP Madrid Protocol. We're going to talk a lot about the nature of intellectual property. We're going to talk about the different forms of intellectual property. We're going to talk about intellectual property that is relevant to SMEs. We're going to talk a lot about your trademarks, the value of brands. Brands are without a doubt valuable assets for your business, and without a doubt the most valuable assets in the world. So we really want to get into this. We're going to talk about the Madrid Protocol. My screen sharing has decided that it's going to stop again. So off we go. Yeah, you can see that from the beginning again. Right, there we go. We're all seeing and hearing good. So off to a great start already. Today we're going to talk about the introduction to intellectual property. We're going to talk about the definition of intellectual property, the types of intellectual property. We're going to talk specifically about trademarks and the Madrid Protocol, and we will end with a conclusion. There's some poll questions, some survey questions, really simple stuff we would want to ask you all along the way. Feel no pressure to answer. If you feel pressured to answer, well, please answer. That would be good for us. If you don't know the answer, you could Google it. I would suggest you Google it, and if you don't know how to Google it, then you could Google how to Google it, because these days Google is a valuable resource. So what is intellectual property? Intellectual property, or IP, refers to the express creations of the mind. And as you can see, regardless of how small your mind may be, once it is an express creation of the mind, it is intellectual property, and it is protected by different forms of intellectual property. Yeah, a key word there is expressed. It needs to be expressed, it needs to be created, it needs to become tangible. It can't just stay in your mind. If it stays in your mind, then you have a bit of a problem insofar as it hasn't been expressed. So it needs to be created. And there's a good example we talk about with this guy. I don't know if any of you know who that monkey is, but his name is Naruto, and he became world famous fairly recently, a few years ago. He took a selfie of himself. So in essence, a photographer came, set up a camera, and put it to take automatic photos. And this monkey came up to the camera in the wildlife. This was in Indonesia. Came up to the camera, took a photo of himself, perfect teeth. I mean, just look at that smile. It's fantastic. Most humans can't take a smile as good as that one. You know, this great wildlife photo. And it became an international discussion as to who should own the rights to this photo. So Naruto took a photo of himself. That was the argument. And we have all these people saying there are a bunch of different owners that are possible in this scenario. So we're going to do a quick poll question as we start. And Gavin is going to put up our poll question for us now. So the question is, who do you think should own Naruto selfie? Is it A, Naruto himself or himself? Or is it the photographer, David Slater? David Slater is a British photographer that took it. Or is it the government of Indonesia, because it was Indonesia, and then it's a monkey that was Indonesia. I'm seeing David Slater and Naruto are neck and neck right now. Okay, no, Naruto taking a step back, David Slater going up. We have the government of Indonesia. It's a very interesting concept that was tossed around. They got experts from various parts of the world to talk about the intellectual property rights involved here. So yeah, it's keep going up. David Slater seems to be on top. People are still voting. It's very, very interesting. David Slater by 59%. He's a photographer. Naruto trailing behind with 31%, and the government of Indonesia with 12%. I think we'll end the polling there. Gavin, you want to share the results? So those are the results there. Naruto, photographer, government of Indonesia, obviously the photographer won. And for those of you who voted for Mr. Slater, the photographer, you would have been right with the outcome of the case. Now, it is not to say that it wasn't argued on all three. In fact, the people for the ethical treatment of animals, PETA, came out and argued that the Wildlife Foundation should own it, the government should own it, even Naruto should own it, the monkey. But the court came down in the end and said, hey, wait, hold on. The express creations of the mind mean the human mind, the express creations of the human mind. It's the photographer who set up the camera. It's the photographer who got the angle. It's the photographer who edited the photo. So there was a lot that the photographer did to make the photo what it was. And insofar as the photographer carried about doing what he did, he was the owner of the copyright in that photo. So I'll talk to you in a bit. I'm going to stop sharing these results now. I'll talk to you in a bit about copyright and the nature of copyright and the nature of copyright in photos, but that is a good clarification as to who can own. There is this big argument now, well, what about new technologies? What about AI? What about artificial intelligence owning intellectual property? That's a conversation being happening at the highest of levels, even at the UN level. But right now, it's the human mind. The person who created the AI would own it in the same way that the photographer who set up the camera for wildlife that had great photos of themselves, the photographer owns it. Moving swiftly along, intellectual property is divided into two main categories. We have copyright and related rights on one hand, and we have industrial property on the other. Yeah. Copyright and related rights is without a doubt massive and gains a lot of traction. You hear it in the news all the time. It's always in our landscape, in our brain space. Industrial property, a little lesser so, but industrial property in of itself is a massive area of intellectual property. I want to say something that may surprise many of you, and I'm hoping at the end of this presentation you would have a full grasp of this concept. Intellectual property touches and concerns literally everything in our world, everything in our modern world. From the clothes that we wear, to the floor beneath our feet, to the roof over our heads, to the toothpaste, I presume, that we all use this morning to brush our teeth, and those toothbrushes. And if you're at home and maybe you didn't brush your teeth yet, all power to you. To literally your cell phone has so much intellectual property in it, it's just mind-boggling. Your cars that you drive or the public transport that you take, everything around us, even the plants around us, touched and concerned by intellectual property. And you'll have a great grasp of this at the end of this presentation. Going back to the types of intellectual property, you see on the left we have industrial property and the various types. You have trademarks, patents, industrial designs. We're going to go through this in short, and then on the right we have copyright and the various forms of copyright. Feel free to take that in for a moment. Copyright is massive. So let's start with patent. What is a patent? A patent is the exclusive right for an invention. Patents protect inventions, yeah? and it's a technical solution to a problem. That's what an invention is. There are various standards and requirements for patents. Patents are fairly complicated documents. Again, the patent is the protection, it's the document. The patent isn't the invention itself, it is the protection for the invention. It is, again, invention is a technical solution to an existing problem. You have process patents, you have product patents. So a lot of things in our modern world are patented. We talk about the airplane. The reason we have transport from one country to another in terms of boats and airplanes is because of patents. The reason we have most of the medications we have in the world is because of patents. Even Gatorade has a is a patented product. It has a patent behind its name for the mixture. You know, the Florida Gators came up with this concept so that their athletes would remain hydrated, and now they have patents and patent protection. Patents are the reason why we have a lot of the technologies, including our cell phones today. You know, it's even this little clicker here. At some point, there would have been protection for the invention behind it. So patents make our world go round in certain aspects. Moving swiftly along to industrial designs. Industrial design is the protection for the ornamental aspect, the aesthetics of something. One of our local success stories is the chubby bottle. The chubby bottle has protection for its design. Apple has had protection for their industrial designs from a long time ago. Lots of watches, lots of perfumes, even buildings. That ice cream cone that you're seeing on the bottom right in the center there, that's a building. That's a building in Chaguanas, Trinidad. A lot of people, you may have seen it and may have taken note of it. Yeah, you can get industrial design protection for buildings. You can get industrial design protections for your toothbrush, for your sink, a lot of shoes, right? So if you are an inventor thinking about inventing things, ornamental aspects, maybe you don't want to get too much into the complications of a patent. You don't want to get into the novelty and to the industrial applicability and those kind of things. Maybe you want to just go with the ornamental aspect, because you know what, when we walk into a store and we are purchasing products, consumers, the first thing that we buy on the basis of is sight, is the visual appeal, it's how it looks, it's how it feels. You know, it's those emotions that that product gives us. Talk about integrated circuits, one of the lesser known and used forms of intellectual property, but they are the circuits that are behind pretty much all technology in the world today, across the entire world. So all our phones, our cars, our washing machines, lots of it have integrated circuits behind them. And the persons who come up with this, the companies who invest money into hiring persons to come up with these circuits, they want protection. It's the same way for patents. They hire people, they hire inventors to create things, to make things better. And that's why they deserve protection for their creations. New plant varieties. So I'm sure at some point you would have eaten a Granny Smith apple, heard about a Granny Smith apple, smelt a Granny Smith apple, spit out a Granny Smith apple because they say it's too bitter or sour. You know, you may have seen the purple carrots, lots of different colors of flowers. Those are new plant varieties. They are new varieties of plants. And I say this a lot, intellectual property is a lot of common sense. If you can make sense of it in your head, then it is self-explanatory. So a new plant variety is a new variety of plant. And just like an integrated circuit is a circuit that's integrated. And lots of plant breeders, they spend a lot of time, a lot of effort, a lot of money creating new varieties of plants. There are new varieties of cocoa. The reason that we can feed enlarging population daily is because people come up with new plant varieties that give more yield for products. So you would think about all our farmers who are here, who are thinking, oh, well, I crossed these two plants and I came up with this new variety of plant. Well, there's protection for you. There's protection to be had. You know, I know that our government now is pushing agriculture, and this is one of the greatest forms of protection that you can get as a farmer if you're a plant breeder and you're crossing varieties. Geographical indications. You know, I have a little display in the back here of a lot of geographical indications, and for any high-functioning alcoholic in the room, this may apply to you and you didn't even know. You know, a lot of the wines and spirits, especially from the European Union and European region, are protected by geographical indications. And what is a geographical indication? It's a sign or name that tells you that a particular product comes from a certain place around the world. So it has to be a physical place, a geographical place. And it can be agricultural, it could be non-agricultural. So we have things like Darjeeling tea from India, our very own Montserrat cocoa from our Montserrat co-op. That middle picture there, you see a bottle. That's their cocoa powder. It is honestly some of the best cocoa powder I have ever tasted in my life. And I am huge dark chocolate fan. All the dark chocolate fans out there, rejoice. All the milk chocolate fans saying, ew, that's disgusting. But moving on, we don't feel hurt by that at all. But Montserrat cocoa, some of the best cocoa you ever taste. You have your champagne. People think, okay, why is it called champagne? Well, it comes from the Champagne region in France. It's where they grow the grapes. It's where they process the grapes. It's where they make the wine. This sparkling wine has to come from that region in France, or else it can't be called champagne. Now, I think many of you may have seen champagne bottles that says made in somewhere else that's not France and not Champagne, France. Well, that's technically not champagne. And champagne, just like Scotch whiskey, you have your Johnny Walker Scotch whiskey, Scotch comes from Scotland. It's whiskey made in Scotland. And those two companies have been on a huge drive to make sure that their brands, their geographical indications are properly protected many parts around the world. We have Parmesan cheese coming from Parma, Italy. You have Parma ham coming from Parma, Italy. There are lots and lots of geographical indications. So if you think that you want to be, perhaps you say, okay, I'm from Paramin and I want to do Paramin seasoning because Paramin seasoning is the best in the country. Hands down, I agree, Paramin seasoning is awesome. And you say, well, maybe we need to monetize this. Maybe we need a centralized certification body who can help these farmers monetize it greatly. You know what? We welcome you. Come talk to us. We can talk about geographical indications. Yeah, it has to come from a specific geographical area. There's a bit of science that goes into proving that it has unique characteristics and quality and or reputation that comes because of that geographical area. So you have to prove that, hey, well, this cocoa that comes from the Montserrat region, it's some of the best cocoa that you would ever possibly have. And yes, I agree. It really is some of the best cocoa you would ever possibly have. And they've proven that to the Intellectual Property Office. And insofar as they have, now they have protection as a geographical indication. So moving swiftly into copyright and related rights. Copyright, again, gets most of the traction when it comes to intellectual property. You see them on the news. You probably heard of the collective management organizations in Trinidad and Tobago. I'm not going to call any names because there are a couple of them here, just over a couple of them. What is copyright? Copyright is the protection for original literary and artistic works. That's Starry Night there, Van Gogh. Fantastic painting. This is one of his Starry Nights. There are multiple Starry Nights, yeah? This is one of the Starry Nights in France. And then you have the Melting Clocks by Dali, and that's a sculpture of it. So copyright can become slightly complicated at times because Van Gogh would have owned the copyright behind his painting, yes, but then a photographer now owns the copyright behind the photograph, right? And then you have underlying works, because what if that painting is still protected? And we'll unpack that. We at the Intellectual Property Office have a lot of information about copyright up on our website, so please feel free. It's a protection for original literary and artistic works. I can't stress enough that word original. It has to be original. What is the standard for originality? Well, there's a lot of case law on that issue. There's a lot of debate on what original is. You would have seen lots of songs that got caught up in copyright battles across the world, not just in Trinidad and Tobago. A lot of content, especially in our online world, that gets involved with copyright disputes. it's your films, it's your books, it's even your computer programs. So we have Mario, one of the most known games in the world. You have Plants vs. Zombies. If you play Plants vs. Zombies on your phone, then kudos to you. Level Plants vs. Zombies 1 and 2, they're great games. Check it out. I'm a huge Harry Potter fan. You know, I have my Harry Potter cup here. Harry Potter is protected by lots of different forms of intellectual property, but then you have a book and you have a film based on the book, and you have so many trademarks involved, and we're going to get to trademarks in a moment. But copyright is a very interesting area of law, a very interesting area in practice, and it applies to all artists and artistes out there, artists being the standard painters and all your other forms of standard art. You have your artists, your singers, your composers, your songwriters, your producers of sound recordings, those kind of things. What is copyright? Again, we come back to this concept of common sense. Copyright is the right to copy. Mind blown. I know it is the right to copy. You are saying that the person who owns the copyright for their original literary and artistic works, they have the right to control the copying of that work. We usually call it the card rights. C-A-R-D. It's an easy way to remember most of the rights behind copyright. You have your communication, adaptation, reproduction, and distribution. Communication means communication to the public, how it is sent in different forms, even in the virtual world. I want to say that it includes virtual copying. Adaptation, if you're taking a work, for example, Harry Potter went from a book to a film, that's an adaptation of the work from one form into another. If you're taking something physical and turning it virtual, that's also an adaptation. You have the reproduction, so the copying over and over, or the virtual copying over and over. And then you have the distribution to the public, sharing it however, whichever form you choose to share it in. Those are your main rights in copyright. Moving swiftly along. How do you assert your copyright? We get this question literally every day. Kavish, I want to know how to protect my copyright. Well, copyright is an automatic right, which means that it is protected automatically upon creation. That seems weird, Kavish, because I heard about copyright registries in other countries. So why can't I register my copyright? Well, those copyright registries are not for the protection of the copyright, because the protection of the copyright is automatic upon creation according to the Berne Convention. Almost the entire world is party to the Berne Conventions, and it says that copyright is an automatic right upon creation. However, when you create something, you need to tell the world that you own it, and that's how you assert your copyright. So therein lies the point of the registry. The registry creates this registration process that says, well, you are the owner of X because you are the creator of X. And therefore, let's prove that you are the creator of X. I put in the film I Am Legend today and in our slide because it's called the copyright legend. It goes something like this. It's a C with a circle, and you put a name of the copyright owner. So if it's me, I'll put Kavish Seetahal. And it would say, all right, the year that it's created, let's say I created it in 2015 or even further back, boom, put in the year, you put all rights reserved. If you open pretty much any book that is subject to copyright, in which case most books are subject to copyright unless it is waived, because yes, copyright can be waived. Most books would have this sentence, sometimes an even longer version of it, in the first couple of pages that says, seen, owned by who, all rights reserved, no part of this book may be copied without permission or upon license, those kind of things. Yeah. There's also something called the poor man's copyright. And it's to take your work, whether it's, let's say it's a book or a manual or something like that, you stick it in a sealed envelope, you register, mail it to yourself, and boom, you keep that register mail sealed envelope in your possession so that anyone ever says, well, I created it on this day. Well, actually, look at this. This is when I actually created it. I register mail it to myself. Alternatively, you can go and get a statutory declaration done by a commission of affidavits. And it's a document where you have to swear. It says in the matter of the Statutory Declarations Act. If you don't see that at the top, it's not a statutory declaration. So make sure it says in the matter of the Statutory Declarations Act. And you're swearing to say that the work that you're attaching to the statutory declaration is yours, you are the original creator, there are hefty fines and repercussions if you lie on a statutory declaration. So don't lie on statutory declarations. Don't lie on statutory declarations. If you need help, the Intellectual Property Office can provide a list of agents and attorneys who can assist you. And there is this new process called Wipo Proof. It's on our online services, on our websites, and it's brand spanking new on our website. I don't think it's actually been used. It came out from WIPO. WIPO, if you don't know who WIPO is, they are the Geneva-based arm of the United Nations that is in charge of intellectual property around the world. And they've created this new process called Wipo Proof, which gives you proof of creation. So you digitally put in your information and it gives you a certificate with a seal on it. There are different levels that you can get that seal, and it is established in multiple countries around the world. It shows that, hey, there is this copyright work that is protected. So that's another option you can go to. Related rights. What are related rights? Well, if you have copyright on the one hand, then you have a lot of supporting persons who help the copyright become a thing. Little did you know, Beyonce may not write all her songs, but she is an incredible performer. If I wrote one of Beyonce's songs and I tried to perform it and put it up on YouTube, let's pretend that 10 people listen to it. I might get that's a lot of traction for me. Beyonce puts up my song because she's Beyonce. Boom, it explodes. She's Beyonce because she's the performer. So you have the related rights in performance. You have performers like Sean Paul. We have pantomimes. That's a pantomime in France there. Producers of sound recordings. So any person who is in the music world knows that the producer has a lot to do with the song. If you have a good produced song, then chances of your song becoming more and more successful in terms of monetizing the song gets higher and higher. You have your broadcasting organizations who spend a lot of money and a lot of time to secure the rights to broadcast in various countries around the world. And a lot of the money today is in broadcasting. So all of those related rights, and they're called related or neighboring rights, they have rights under copyright and related rights in our legislation and around the world according to the Berne Convention. The rights in copyright, we have the economic rights called the card rights. We spoke about that already. We have the moral rights, which is the right to be named as the author, not to have your work distorted. It's retained after the work expired. So if you take a photograph, you have the right to say, hey, I want my name on that photograph. Now, it can be waived in writing, and that happens quite often when you have contracts. So you want to think about your moral rights. So you want to think about the moral rights of others when you are engaging someone to create copyrighted works for you. General rule with copyright is that the creator is the owner. And there are a couple exceptions to that. The course of employment, if it is created as per your duties and responsibilities and you're employed, then it is owned by your employer. When we say employer, we do not mean an independent contractor. So if you're hired, let's pretend you hire a photographer to do a shoot on a specific set, and you aren't paying the NIS and stuff like that, you know, paying the taxes, then they are not your employee, you are not their employer. That is an independent contractor, and that is a different situation, in which case independent contractors, we go back to the general rule that the original owner is a creator. The independent contractor would be an original owner and they would be a creator, and then you have to assign the copyright in writing. An assignment has to happen in writing. It has to be assigned and signed by the owner, which is the creator. Yeah. So if you are an employer and you have hired somebody as a photographer on a 9-to-5 basis or 8-to-4 basis, and they're coming in and they're doing all this work for you, and it's part of their duties and responsibilities, you're paying their taxes and NIS and stuff like that, then it would be under the course of employment. But you can't expect everything that they create to be yours. So you have to remember that it's based on the duties and responsibilities as an employee. Yeah. Copyright, as I said, is automatic. There's no registration requirement. There are registration processes in different countries. One of the most notable would be in the US. As a general statement, the duration of copyright is the life of the author plus 50 years. There's a conversation being had to increase that to 70 years after the death of the person. So life plus 50. That's why Michael Jackson's estate still owns the copyright in a lot of the works. Yeah, that might be extended to 70 in Trinidad and Tobago. We're having the conversation about it. We're having stakeholder consultations about it. So stay tuned for that. Let's talk now about trademarks and Madrid. What is a trademark? I put in Sasha there. Sasha is a brilliant brand. What is a trademark? A trademark is any sign capable of being represented graphically. Now, this is straight out of our Trademarks Act. Our new Trademarks Act is Trademarks Act number 8 of 2015. It's on our website. Please feel free. Google it. Google us. If you don't know how to Google it or Google us, then Google how to Google it or ask somebody for help to Google it, because I'm sure somebody will be able to help you Google it. It has to be represented graphically, which means you have to put it on paper and you have to show us. You can also file electronically. It has to go in our application form, and there is keywords. It must be capable of distinguishing the goods or services. That's the standard for trademarks. So it has to tell people that a particular product or service comes from a certain proprietor, not from a certain place around the world. That's geographical indications. It can be anywhere around the world. It has to come from a certain person or proprietor. Yeah. So you think, well, what's the value in that? What's the value in a brand? Brands are, without a doubt, the most valuable assets around the world. Brands are the most valuable thing your business would put into its business model and into its business plan. Your brand sets you apart. It is a badge of origin. It tells people, this is my product. This is the quality that I am giving you. This is the price I am giving you. I'm telling you that you have the opportunity to work with me, even to tell potential investors, hey, this is my brand, this is what I'm putting out, this is the quality, and if you want to invest, come talk to me. This is where to find me. This is how you can find me. I'm sure many of you, when you see a brand, you Google them. You go up on, or use some other form of internet search, whatever your internet search is. And that's the value of a brand. I remember once I bought a t-shirt and there was no brand on the t-shirt. And it was one of the most comfortable t-shirts I'd ever worn. And I could never buy another one because I didn't, when I went back to the store, they didn't have any of that. And there was no brand. So what was I supposed to do? How was I supposed to search them up? How was I supposed to find out if they're on, let's say, Amazon or some other type of mailing service that I can purchase stuff from? If they have a store in some part of the world? No, you can't. So that's the power of a brand. And your brand is one of the most valuable things you would ever have. Companies who take their brands seriously are companies who their brands are valued very highly, and companies often measure success in the international realm based on the value of your brand. So I want to tell you, if you haven't registered your brand yet here, or perhaps you are thinking about registering your brand, maybe you're having the conversation, maybe you're thinking, well, I don't know whether registering my brand makes sense. I'm here to tell you, registering your brand is one of the most valuable things you can do for your business, and you should do it, and do it soon. Now, I don't want to get into the debate between Carib and Stag. It's a huge debate online. I'm sure many of you have seen this. This is on Pigeon Point Beach. So you have a beautiful background. This is our country. But a brand must be distinctive. It must distinguish you from everyone else. It must set you apart. And the best brands in the world have nothing to do with the product. You think about Carib. What does Carib mean? Carib refers to perhaps the Caribs and the Arawaks, who are the indigenous people of the islands. You think about Stag. What does Stag have to do with beer? Absolutely nothing, you know, but it's become synonymous with our local beer. Why? Because it's a brilliant brand. Carib and Stag, just brilliant brands. It tells you nothing about the product, because if you stick beer on it, like the word lager is on the Stag, if that was your brand, that's not a brand. It tells you what the product is. And anyone who makes beer or makes lagers, it has to be able to put those words on their labeling because, well, it's beer. So you have Carib Pilsner being a type of beer. I know when you may walk into a bar and say, well, Pilsner, and people know you're referring to Carib, but that's not the brand. The brand is Carib, yeah? And it's so distinctive. It's ingrained in you. People see the brand. It's the first thing that people hear on the phone if you're ordering. It's the first thing that people see when you're in the grocery. Those brands, good brands, they're ingrained in your brain. You can see it from across the room, like the Nike logo. You see it from across the room and you know exactly what it is. The most valuable brands in the world according to Interbrand. So yes, Apple is number one. Yes, you know, for the Apple haters, you know, Apple is the number one brand right now in the world. And if you can look there, you can see lots of tech companies. Apple, Google, Microsoft, Facebook, Samsung, Amazon, even Disney, a lot of tech in Disney these days. Disney Plus, I believe, launched this week in Trinidad and Tobago. So you can get all your Disney content legally. And I want to stress this, please use legal platforms to get your content. There's Netflix, there's Disney Plus for music, there's Deezer, there's Spotify and other jurisdictions. We're clamoring for Spotify to come into the country. So you have the most valuable brands in the world here. So I have a quick poll question, and Garvin is going to put up our poll question number 2. Don't worry, I know I'm long-winded and I talk a lot, but we'll have a break shortly. So what do you think is the value of the Apple trademark? Do you think it's $241 million US? That's a lot of money, right? Do you think it's $2.41 billion? Wow, $2.41 billion. Or do you think it's $241 billion? Just think about that. The Apple brand is the most valuable brand in the world. Just taking this for a moment, the most valuable asset is not a piece of land. It's not jewels. It's not crown jewels. It's not a building. It's not some other piece of property. It is intellectual property, and it is a brand. The Apple brand is the most valuable brand in the world. And it has been valued in multiple countries, and Interbrand puts it as number 1. So a minute has passed, and I think we've had all our voting in. There's a battle between 2.4. People still voting, yes? And the results are 241, everyone said. If you chose $241 billion, you would be right. Imagine the Apple brand. It's worth over. It's 241.2, I want to say, somewhere there. $241 billion. That is the value of a brand. And imagine, just think about this. Apple started in a garage. You know, the Apple company, Macintosh and Apple, went through several failures before they are the tech giant that they are today. Apple is an amazing success story, and their brand has been a huge part of the success. So I want to tell you again, if you haven't registered your brand for your business, if you're now starting up and you're thinking about your brand, you're thinking what to do with your brand, you know what, contact us. We can give you information. We can help you. Call Judy Marie Rock. She is on call 24/7, 1 o'clock in the morning. She will answer that call. She will respond to you. Right, Judy? I hope you're hearing. So, moving on from that poll question now. Next, this is a picture of the Louvre. Just on the outside of the Louvre in Paris. And that's the iPhone 11 launch on the side of the Louvre. All the money goes to the upkeep of the Louvre, but think about Apple being on the side of the Louvre. I mean, I think about the Louvre being this traditional set of art, but the Apple brand and the iPhone, the company Apple, they considered it art. So they put it on the side of the Louvre, not just for advertising, but as a statement piece to say, listen, we're bringing art to the world. That's the brilliance of a brand, and it's always attached to the Apple brand. When you think of Apple and you think of the picture of an apple, yeah, you might think about Granny Smith apples, and you might think about when you spit out a Granny Smith apple, if you've ever done that. But you might also think of computers and phones, because that's what they are, computers and phones. Apple, they took something innocuous that has nothing to do with the product, and they made it into one of the most recognizable brands in the world. A brand can also be a name and a logo, so it doesn't have to just be an image. You have the word Apple, you had the image of the apple as well. So you have KFC, that is one of the most known logos in the world. Yeah, again, we put up our Shandy Carib, so for the people that were saying, well, Kavish, you had the alcoholic beers, well, I pull up the non-alcoholic drinks too, you know, everybody had to be there. So you had the Shandy Carib there. And when you think of Carib again, you think, right, I know exactly which brand you're talking about. So it could be a name, it could be a logo, the logo of KFC. You know, it's one of the most brilliant logos, in my opinion. It's that silhouette, it's that drawing, it's etched into your brain. You think about KFC, yeah? And well, a lot of people swear by KFC to be a Trinidadian thing. Obviously, it's not Trinidadian, but there's an argument that the best KFC comes from Trinidad and Tobago. I may or may not ascribe to that argument. You have your domain names. Yes, that is again KFC. But we have KFC. This is in Switzerland, so you'll see www.kfc.feedback.ch. Your domain names can be registered as brands. So we have marshamontano.com, you know, saying, hey, you can register your domain name. Obviously, the www and the .com is in of itself not registrable, because that refers to your domain. But you have your domain name that you would have to apply for, that you would have to get approval for, that if you lost, you can go to ICANN and resolve the dispute if someone took it from you. So you have lots of brands now that are literally domain names. Slogans, I mean, our local rituals, you have grounds for enjoyment. Brilliant, just sheer brilliance. Grounds for enjoyment. It's coffee grounds. Grounds for enjoyment. You can register your slogans, people. You come up with a slogan that sets you apart, register it. That's how it is, yeah? So one of our local brands, the current controller of our intellectual property office, Mr. Reagan Asgarali, was part of the legal team who came up with rituals, and his story goes like this. The owner asked his wife, as many of you might want to ask your spouse for advice. He asked his wife, well, his wife said, what does coffee mean to you? And he said, it's my morning ritual. Boom, rituals, what a brand. What a thought concept, you know? Think about that in its simplicity, but its beauty. You have signatures. This is Dr. Seeger's signature from Angostura. If you don't know who Dr. Seeger is, I implore you to Google him. He helped create bitters. Bitters is known in over 100 countries around the world. Angostura is one of the biggest brands around the world, and it comes from our very own Trinidad and Tobago. I have visited a few countries well at this point, and it's fun to always see Angostura on shelves, the bitters, to see our product and a local brand across the world. It's fantastic. So if you're thinking, hey, I like my signature, you know, my signature does look real nice. Boom, you can register your signature as a brand. You talk about your image and your silhouette. So you're showing with Chester's image there, you know, that was his stance. That's his thing. He got that registered as a trademark. You have the famous, sometimes infamous, jokes, the famous Usain Bolt lightning bolt stance. You know, that's a registered trademark in Trinidad and Tobago as well. This is in his bar in Jamaica. You know, he has a lounge and bar, and you know, it's all over his bar. You go to Jamaica and you hear about Usain Bolt because he's on people's lips. He is a national pride, you know, and he's known for this one thing. He created, molded that brand himself. So you think about even your image, your silhouette. Maybe that's something that you want to do for your brand. We also have sound marks. So a lot of y'all, and I hope you're able. That right there, play it one more time. one of the most distinctive sounds in the world is that MGM sound, that MGM roar, and that is a registered brand. So it doesn't have to be a conventional marks. With the new passage of our law, we have non-conventional marks. So we have things like sound marks, and this was the filming of this sound, you know. Yeah, may not be want to be so close to a lion. I don't know about you, maybe that's your thing. I like lions, but maybe not so close. But they filmed the lion, and now it has become one of the most distinctive things in film. To hear that roar, you know automatically which company you're talking about. You have different types of brands. You have colors. So the bottom of the Louboutin shoes, like that's a brand. Home Depot's orange, that's a brand. So you're thinking about your colors. Now, color marks are not your mark in color. I just need to be clear. Your mark in color is different from a color brand. A color brand has to be proven to be very distinctive, and that one color sets you apart. So it's literally just the color. So literally on an application form with Home Depot, in the box, they would only put that orange, sorry. In Louboutin, it would just be that red. And that's the registration that they're looking for. Those are your color brands. They are registrable now in our Trademarks Act. So please feel free to call us if you're thinking about a non-conventional mark, like a shape. Shapes are registrable, like scents, like tastes, like your trade dress. Chanel is a different smell. There was some difficulties with Chanel, and I think they're having a court case with it. But one of the proposed one for taste is the mango chili. Maybe you've tasted it. Maybe you say, I'm not too sure about this mango chili thing, you know. Casey, not too sure. But it's huge in many other parts of the wider region, in Latin American and Caribbean region. We have our shapes like the chubby bottle. That is registrable. They said, we need something that fits in the palms of children, that's easy for them to open, that could fit in their lunchbox, that could stand on a table easily. We're going to register the shape as a trademark. Get an industrial design, register the shape as a trademark. Boom. You have shape as a trademark. So if you're thinking about the shape of your product, you're thinking, I have a specific scent that I've created that has nothing to do with the product. For example, there are rose-colored, rose-scented tires. Not rose-colored tires, but although that would be interesting. The rose-scented tires. Now, when you burn out, they smell like roses. You get that whiff of roses instead of smelling burnt rubber. I mean, if you're on the racing circuit, you might like the smell of burnt rubber. But imagine burnt rubber and roses. That was a trademark, as a scent trademark. So you want to think outside the box. There are new non-conventional ways of doing trademarks. Weaker marks are things that are generic, things that are descriptive, but things that are arbitrary and fanciful and distinctive. They're stronger. They say nothing about the product. They say nothing about the nature of the product or service, but it sets you apart. It tells people, come to me. Again, we go back to Apple. Apple for computers and phones. Apple for tech, just brilliant. Talking about Royal Castle is our local own, you know, the flavor that makes all things better. Under the new act, all prior registered marks are now registered under the new legislation. So if you have a registration under our legislation, the old legislation, knowing that the new legislation has come into force, do not fear, it is registered. Just like the Royal Castle mark is registered and has moved forward into the new act and has been registered under the new act automatically. So this is the process for a trademark. It's fairly involved process as the office. So you start with application, there's formalities, classification. We search for the rights of others to make sure that you are not encroaching upon the rights of others, because the trademark gives you a monopoly. It gives you a complete monopoly over what you have filed, including registration, protects things that are similar. So if there's a slight differentiation that someone is filing for, they will be blocked at this office if you're registered here. So never fear, someone can't just take your mark, make a couple tweaks, and then file for it. It doesn't work like that. Trademark protects even similar things. That's the nature of a monopoly. So we examine the mark after the search, and once it's accepted, we publish it. It's published on our online journal, available on our website, www.ipo.gov.tt. There is a period that is left for opposition. It's a 3-month mandatory period. You have a 3-month period that you have to wait for oppositions. And these oppositions happen not as frequent as people might think. It is not something that happens all the time, but anyone in the world can have the opportunity to oppose the registration of your mark. So I always say to people, make sure you're creating something original. And if you are, let's pretend you are a licensee, make sure you have the permission of the holder, the registrant, the proprietor to register the mark or to register the license to the mark. Yeah. After the opposition period, we have registration and we have renewal. Formalities is just going through, make sure the forms are properly filled out. You can always say, okay, I want to contact the office in advance to make sure I go through my formalities. Please feel free to do so. We are available. There are forms up on our website, so you can go through them. You have the NIS classification, and NIS named after the place that the agreement was signed. The NIS classification is a special classification for trademarks that puts your trademark into the course of trade and to the specific channel of trade that you are going to be trading in. So you think about what you are doing as a company, as a business, as a proprietor, as SME, as an exporter. Think about, okay, I am doing textiles or I'm doing clothing. Well, there's a way that we classify that. We have a Madrid Goods and Services manager up on our website that can help you classify it. So go on our online services. If you feel the need that you want an agent, yes, we always promote our agents. I know there may be many of our agents listening on right now. So shout out to all the agents and attorneys here. Big ups to them. And if you need to get in touch with an agent, we can provide you with a list and we would help you get into contact with them. We search for rights. Usually it's prior rights to see which is prior registered. Sometimes there are multiple persons who applied in just about the same time for sometimes the same exact marks. And those situations have proven difficult at times for the proprietors. So we search to make sure that everything is above board. And then we examine. After examination, we accept. Should it be acceptable, we publish. You have the opposition period. There is the opposition period, and an opposition process is very much like a court process. You have to file documents. You have to usually get an agent to help you with that. If you are an international person, to file now, you need a local address for service, and you would have to get a local agent involved to do that. Then after it is granted, you have renewal. Trademarks are protected for 10 years, renewable indefinitely. So your trademark could last for as long as there stands an intellectual property system around the world. And again, intellectual property makes the world go round. Everything in the world is touched and concerned by intellectual property, so it's not about to go away. So before we go into the Madrid Protocol, I'm going to stop share my screen now, and we can talk a bit and have a little Q&A session. Judy, I don't know how you plan to do this because I see there's a lot of questions.
Yeah, there is.
Ranjana made a comment that Judy is near to saying that she has never met me in her entire life. Ranjana, I'm sure you may be right that Judy may be having some choice words for me after this meeting.
You're a wonderful presenter. You're very engaging, and I'm sure that all of our participants agree with us. But with the number of questions that we have, we'll have to run it through very quickly.
I'm seeing lots of questions. So can you?
Yeah, we have like 2 pages of questions. Yeah.
So
that's why I said you're engaging.
Yes.
Okay.
Can you take me from the top, please, Judy?
Okay. So Ms. Phillips said, hi, Kavish. Did you say that IPO proof registration?
Wipo Proof registration.
Yes, thank you. Being hosted
Right.
through
Okay, so
the IPO website?
yes, well, it's not being hosted through the IPO website. There's a link. We don't host it. That's WIPO, so they're the UN body. We provide a link. We provide the connection. We can speak to the copyright division with WIPO if that needs be, but we don't actually control what's going on with the Wipo Proof. That is a UN thing. Yeah.
Okay.
So that, I hope that answers your question, Akila. The next one would be from Ines King. I hope I'm pronouncing your name right. If I butcher your names, please, I'm sorry. But Aid or Ade, I've seen websites that it's their right to copy as C copyright owner 2020, 2015. All right, I supposed to state a range of years. No, you're not really supposed to state a range of years. Usually it's years created because copyright lasts from the point of creation until, as I said, the death of the author plus 50 years. But that's standard copyright. There are different forms of that. Like if you create it together, if it's film production, there are lots of different permutations of the extent of copyright. The range can usually be due to some type of arrangement that that company would have with other companies. So maybe they are signing their rights after a certain period. Maybe they have licenses happening. Maybe they have the rights in a certain territory. Copyright can get fairly involved and agreements can get fairly hectic. So I suggest that if you have something that is in depth with copyright, I suggest you go to an agent, go to an attorney. I'm sure they would be of great help to you. If you have further questions about that, you can feel free to ask. I'm seeing another question from Andre. I have a question as it pertains to copyright in the music industry. What rights does the music video production company have? So the sound producer, the production of the sound recording, is usually owned by the music production company. The music video production company, which would be different from the production of the sound recording, has different rights in copyright. So when you produce a video, you would have rights in copyright for your videography. That is protected under copyright. So yes, you do have rights in your music videos. But in order to create the music video, you would have to have the music, and you would have to have actors, and you would, if you're creating actors, perhaps you're creating some type of animation and someone is being hired to do the animation, and that animator would have to be hired, and they would have copyright. So again, it can get fairly involved. As I said, I knew all of these questions would be about copyright. So does that make sense, Andre? If you have any questions, again, feel free to contact me. We have another question from Mark. If I score notate music from a composer who cannot write music, who owns the score? Your score on Mark would be an adaptation. And there are adaptation rights in copyright. But again, you would have created something with an underlying right. So you would have to get the permission of that person who owns the music in order to create that score. I hope that makes sense, because you don't own the music, so you have to get their permission. The permission to monetize, because anyone could score any music for your personal use. Like if I create a score for my personal use of any pop song these days, it's for personal use. I'm not trying to monetize or commercialize it, but if it's for commercial purposes, you're gonna have to get permissions. Yeah. So there would be multiple rights involved, the composer and the person who scored it. Andre, you said, especially in a situation where you have not been paid by the artist, if you're not been paid, that's a discussion to have with the artist. So perhaps you want to be paid, or perhaps you want to have an agreement with them to say, hey, the copyright in this thing, for the adaptation rights in copyright for the score, I want to monetize it, and I want to be the only person who monetizes it because I created the score. I'm gonna pay you X amount for your permission, that kind of thing. So it depends on your arrangement. Some music creators would say, some artists would say, well, I want 20% of everything that you earn. And that's their right to say that, because they created the music in the first place. Yeah. So you'd have to think about your arrangements, think about having your arrangements prior to monetizing, because you don't want to be in a situation where it comes up after and then you are in hot water thinking, oh my God, what have I done? I should have gotten these arrangements. I should have listened to Kavish when he said, one guy agents, you know, just, why did I not listen to Kavish? You know, listen to Kavish. We have a question from Chris Brooks. How are fees calculated by collection agencies? There are international standards for fees, Chris, that, for example, COT is a member of some international organizations. There's a regional organization called Access. They are with IFPI and things like that. I don't want to get into the nitty-gritties with COT. You can always call COT. I don't work for COT. So you could always call COT. If COT you're on here, Ayana, if you're on here, Ayana, feel free to call her just like Judy. Ayana is on 24/7. Ayana is great to talk to, you know, so give her a call. There is, and I don't want to step into the boundaries of the UN, but there is a project ongoing for the regulation of collective management organizations in Trinidad and Tobago and throughout the entire Caribbean region. It's done by WIPO, which is again the UN body. So that is being regulated now. It's being proposed, regulations are being proposed. So you can always look into that. We have 2 local PhDs who are in charge of that, Dr. Barnes James and Dr. Koo. So again, you could get in touch with them and they could inform you about the process and things like that. And so how does this work for the performers, and are they paid directly? Again, that's a CMO thing. The Intellectual Property Office is not a CMO. We do not get involved in the management of artists. That is for the collective management organizations, and that's it around the world. We help engage the CMOs in what are called tag regulations. So we can get more into that at a different time. Feel free to Google it again. Moving on to Kendall. Kendall, if you paid someone to design your company logo, who does the copyright belong to? Kendall, again, good question. I go back to the slide on the owner of copyright. The creator is the owner. So if someone, as an independent contractor, created your logo, technically they own it. There is an implied license involved when you pay them that says that they are supposed to assign it to you. That assignment, however, needs to be in writing to transfer ownership. There's no stamp duty or anything involved, but just like any other piece of property being transferred from one person to another, it has to be assigned and must be in writing and must be signed by the owner. So you can visit any one of the agents to get assignments done. They can, again, it can be very complex documents, especially if there are multiple rights involved. If it is an employee of your company, let's say you hired and pay NIS and taxes and whatever for the company, you hired a graphic designer, then technically the graphic design belongs to the company. For people who work for ministries, like Judy works for exporTT, what she creates in the course of her employment would belong to exporTT, and she would say, well, no, I want ownership over it. Well, Judy, I'm here to tell you that no, you don't actually own what you make in the course of your employment. It is owned by exporTT and the government of the Republic of Trinidad and Tobago. Right? We have Titan Chambers asking, hi Kavish, now that trademarks are being published electronically in your online journal, have the fees changed? Yes, the fees have changed. You can get the new table of fees on our website. That's a great question. All of them have been great questions so far. Titan, yes, the fees have changed. At one point, we were the lowest set of fees in the world, or one of the lowest. So, yeah, we hadn't changed the fees for 30 odd years, and we had significant stakeholder consultations with all of the agents for intellectual property in Trinidad and Tobago. We had consultations with international bodies, and there are new fees. You can check out the new table of fees. We've cut out a lot of the processes and process fees. So things like publication is done for free now, which could have cost possibly hundreds or thousands of dollars with the publication agencies. We are working on getting electronic certificates soon. so that we can help reduce that fee as well. So there are no more disclaimers, no more associations. So we reduce fees in many other regards. So there's one upfront fee that you pay, and it depends on the amount of classes you're filing for. I don't want to get too much into the nitty-gritties of the application fee, but there's one fee that you pay up front, and that is from 0.0 until registration, and then you have a renewal fee after 10 years. You have your certificate fee, but there's no mandate to get a certificate. If you don't want a certificate, you don't have to have a certificate. Usually people get certificates when there's a problem. So someone says, oh, well, maybe you need to prove that this is your brand to someone who's trying to rip off your brand. So you get a certificate. This is my brand, yeah? Right, we have Judy Marie saying that she's going to have the recording on exporTT's website. Thank you, Judy Marie, for that. Risha Alain says, due to COVID-19, business name search and registration have gone well into 2021. If you have a business name, how can you make it legit / copyright? Should I mail the name to myself? So there is a bit of a set of jurisprudence in copyright that says short phrases and short terms are not really subject to copyright. So a name is in the realm of trademarks, not copyright. If you're doing like your business model or your business plan, that is a page or perhaps a book or just a short manual or something like that, you can do the whole copyright process, register, mail it to yourself. But when it comes to business name search and registration, that's with the company's registry. We always promote getting your trademark with your business name, because your business name, as I've explained to a lot of people, your business name is like your house. It's your bit of shielding and protection that you put your valuable assets into. So you park your car, you put your expensive big screen TV, you have your air conditioning units inside your house. We're protected. So your company is your legal protection. It offers that framework of protection, and your business name is a smaller form of protection in that regard. And then your assets, like your trademark, like your property, like your vehicles, like your anything else, any other assets that your company may own, you put it inside that legal framework. Does that make sense? So your business name, you can get registered as a trademark. There's no guarantee that if you register your trademark first that you can get a business name after. You can do the company search to see if it's free online. There's an online search. I'm not sure whether it is completely up to date. That's one you would have to call the company's registry. We at the Intellectual Property Office, while we are part of the Ministry of Legal Affairs, we are not the company's registry per se. We do have conversations with them, so we can help make contact and things like that. But you can always search on their website. Ranjana, again, yes, I'm sure Judy doesn't like me off this. Granny Smith Apple make good pies. Yes, agreed. 100%, Jeanette. Can you briefly outline the process on having your brand registered? I think I went through that, Carissa. But again, you file here. I'm going to go through the methods of filing in a short bit. So we'll have the methods of filing, and there are multiple methods. You can do it online now, which has been a great thing for us, especially during COVID. So you can file online, register online. Literally everything can be done online. You can send us correspondence online. It's a dream. So there's filing, and there are a bunch of things that we do. Then we write to you, tell you if there are any issues with the mark, we tell you, and it's all communication virtually over email and stuff like that. And we try to help you get to the point of registration. And once registered, then you can file for your certificate. Yeah. The cost to register, upfront cost, if you file it in one class, is $1,400. I know that sounds like a lot, but again, there are no other costs involved anymore. There used to be other costs like disclaimers, like associations, like publication. So we've cut out all those costs and put them in one upfront cost. And if you think about it, it's $1,400 for an entire 10-year period. So for me, that's value for money. Yeah. A lot of people have noted the increase, but we're still on the lower end of international standards when it comes to fees. So you're welcome. If you've been using a brand name for years, this is from Catherine, but it's not registered, can someone else just go and register it? Someone else can apply. In terms of searching, Catherine, we do lots of searches, including searching to figure out what's out there if someone else is trying to make what is called a bad faith application. And yes, that is incorporated into our law to see if the brand is registered. Let's say you've registered in other parts of the world, other territories. You haven't come to Trinidad yet, or maybe you are a licensee and you are importing something, and maybe you are the hub in Trinidad and you're exporting to other islands. You haven't registered in Trinidad yet, because you're organizing with the owner. Yes, we do searches in that regard. Someone can file, nothing is stopping people from filing. We don't question at the stage of filing usually. If there are red flags being raised, we do raise red flags sometimes, and we ask, and a lot of agents here might say, yes, we've seen those letters from the IPO. My God, I'm so tired of these letters. But it's these asking you, hey, are you the proprietor? What's going on here? We seem to have some conflicting information. So yes, we do detailed searches, if that helps answer your question, Catherine. And as always, take my, I can't give legal advice because I work for the government of the Republic of Trinidad and Tobago, so I can't technically give legal advice in this regard, in this specific regard, but I can give you information. Please listen to Kavish and register your brands. Yes. You can submit an application online for a trademark. That is correct, Peter. Yes, you can. I'll walk through that process very shortly. Can you talk a bit about sharing IP ownership and best practices for contracts, agreements as it relates to the protection for industrial copyright? So there is no one standard, Ade. I hope I'm pronouncing your name right, Ade. There is no one standard for, especially for industrial stuff, especially for commercial stuff. There are so many permutations. Best practice is to make sure that you have all your P's and Q's lined up, that you cross all T's, dot all I's, make sure that everything is abundantly clear, and make sure that someone who has experience in intellectual property is looking over these contracts and agreements. I'm not trying to down anyone else who may not be as experienced in intellectual property, but IP is a rabbit hole in itself, and every different form of IP is a rabbit hole, and then within those rabbit holes you have other rabbit holes, and so you could be thinking about these agreements and things for months and months and months. IP experts obviously would be able to deal with it on the fly because they know what they're doing. So I can't stress it enough. Make sure you have IP professionals looking at this. You don't just want random persons, maybe down the road. Maybe it's a person down the road who you've been listening to, and you ask them. Make sure they're IP expert, yeah? Mariana said, for future reference, I believe the photo used for your niece slide is actually a photo of Manarola Cinque. I want to say Cinque, Italy. Thank you for that, Mariana. I Googled Nice and that's what came up. I haven't been to Nice. I wanted to go to Nice. When I do go to Nice, I will have my own very photo. I will change that photo now after this presentation. So thank you. But that's what Google sent me to. Google, it's how you use it, yeah? If you don't know, then now you know. Can we register an international trademark? I'm going to talk about this in the very, very near future. So when we go back into the slideshow, it's going to wrap up this Q&A. There's no such thing as an international trademark. HEMA, I'll pronounce your name right. HEMA, there are regional trademarks. There is an international filing process, and that's what we're going to talk about now, which is the Madrid Protocol. But there's no such thing as an international trademark registration. Trademarks are jurisdictional, which means that you have to file and get protection for it in the specific jurisdiction that you are filing in. So you have to choose your markets carefully. It's where you plan to export, it's where you plan to import from, it's where you plan to operate your commercial enterprise, those kind of things. So you probably, you get a greater sense of what I'm talking about when we go through the Madrid Protocol. Richard Trotman says, how can you protect collectively created IP within a company? Say you're experimenting and developing new products or formulations. Is there a standard declaration or waiver that I can get for all my staff to sign? In your employee contract, I suggest you include an IP clause that says that anything created in the course of employment, and again, it has to be in the course of employment, belongs to the company. So that would be a waiver of sorts in your employment contract. If you had an attorney or someone experienced in employment law looking at your contracts, perhaps just give them a suggestion that you want to add an IP clause for ownership, because it's important. In my private practice, I have drafted employment contracts with IP stuff in it, so it's not unheard of. Lawyers know where to go and find precedents for it. There's an entire book called Clauses Precedents. So yeah, A to Z clauses, you could go and look at that. If you're doing it yourself, there are books out there that you can read. Sometimes it helps to just make the investment and get it done right beforehand. If you're going to do it now, again, just get it done as soon as possible, yeah? What rights does a graphic artist own on artwork for your logo? So Solange asked about graphic artists. I have 24 new questions. People, I'm giving this 8 more minutes and then we're really going to have to go into the rest of the presentation because I don't want to keep you all back. But what rights do graphic artists have? I think I've answered that question. The graphic artist, as a creator, would own the rights to their graphic art. If they are employed as an employee of the business, then the employer would own it. But if they're an independent contractor or they're working by themselves on stuff, the graphic artist owns the copyright in their logo label. Kendall comes back and said, I did a search out of curiosity on the IPO.gov site, and it says that the Pfizer trademark expired in 2019. So does it mean that someone can use it in Trinidad? Just asking. That is a no, a giant no. Pfizer doesn't have one brand, they have multiple. We are currently updating our search. We're gonna have what is called Wipo published in the near future. So all our current information, very up-to-date information will be available. And we try to update our search facility as often as possible, but I do not think it's been updated to today. So it could be that the Pfizer brand has been renewed. It could be that there is a process for renewal going on, because even though Pfizer may be renewing that one brand, they have multiple brands that they renew simultaneously. So it could be that that one mark is pending. And I can't stress this enough, you don't want to steal Pfizer's brands. Especially after, I mean, Pfizer created one of the vaccines for COVID-19. So let's work with them. We hope that vaccine would help the world. Hope that answers your question, Kendall. Hesma, my apologies, Hesma Tyson says, I registered my trademark in 2019. Do I have to refile in order to be a part of the Madrid Protocol? There's a separate filing process to be part of the Madrid Protocol. I'll go through that shortly, Hesma. If my brand is based off a silhouette photo that I took, however, it was given to a graphic designer to create the final product, well, it's the explicit right. So there would be multiple rights involved. The graphic designer would have some rights in your underlying work that you have rights to, because you have given it to someone to add their professionalism to it. Yeah. Presume that the graphic designer would have done a fair amount of stuff to it and would have edited the photo in a significant way, or even in a lesser way, but they've added their professionalism to it. So you have that give and take there. Akila asks, hi Kavish, for non-conventional trademarks, they must be graphically represented. Yes. So for sound marks, you have to write out a notation. We would still ask you for the sound bite. Again, it has to be a trademark, so it can't be a 3-minute song. If you listen to the sound marks around the world, they're like these couple seconds of something that you hear and you know off the bat. Yeah. Looney Tunes has one for their opening, that opening registered. So you think about the length of your trademark, because if it goes longer, you're talking about copyrighting the song rather than trademark, yeah? So it must be graphically represented. Same for sense sounds. There's something called chromatography that you'd have to go and get a chemical breakdown of it. There would need to be a description of the scent and the taste, things like that. So there are ways to graphically represent it. There are some guidelines in various places. When we get into non-conventional marks for people who are filing, it is the exception, not the rule. Most companies don't have non-conventional marks. So when we get into it and people want to file, please contact us beforehand, because it's not something that you're going to file every day. It's not something that companies file every day. Yeah. Right. Judy says we have to wrap. Judy's the boss, right? We may have to collect the additional questions. I'm just going to go through one more question or two. Andre says, if I register my business name in Barbados, can someone then go to Guyana and register the same business name? It is possible. Business name registrations are also jurisdictional. Not for well-known businesses, not for well-known names like Apple and Microsoft and things like that, but it is possible. I'm not saying that it isn't impossible, because, listen, there are thousands, if not hundreds of thousands of business registrations around the Caribbean alone. So there's that difficulty. If you're going to set up a commercial presence in another country, you're going to have to go and register your business /CUHs. Could exporTT assist with trademark registration? Call Judy Marie Rock. How can we search and narrow non-traditional marks? We don't have any non-traditional marks registered in Trinidad and Tobago. When we do, we will put it up on our website. So, like for example, the USPTO's website, you can literally search all their sound bites for their sound non-conventional marks, and you can listen to them. You can even download them, and they've given permission for that, those kind of things, so you can hear it. So yeah, we would, but we don't have that process yet. Desperados plays Nyla Blackman more soca and wins Panorama. Can Nyla make a claim for prize money? That is a very interesting question, Mark, and I don't want to get into that because that is an entire conversation. Suffice it to say that that is a public performance, even an adaptation to take it into another type of work. So they take the song and they played it, they adapted it into a pan arrangement and then played it. So you would think about contacting the local CMOs. I'm not sure if Nyla is a member of COT, but it could very well be that she is a member of COT. So you would want to think about that. Nikila asks, can your trademark be a different name? Yes, your trademark can. That is a great question. I'm glad you raised that. Your trademark can be a different name from your registered business. Apple has dozens, if not hundreds, of trademarks that are not Apple. So yes, you would, in a perfect world, you want your business name and your trademark to be one and the same, and then you have other trademarks under your business. But if sometimes that's not possible for various reasons, I'm not going to get into it here. But yes, it can be different, it can be the same. Catherine asks if someone could steal your brand name if you haven't registered. If someone could steal, I think I answered this fairly on a past question. They could file, they could try and steal it. There are stuff called pre-action protocol letters. They are rights in unregistered trademarks under common law. So you can get an attorney to write a pre-action protocol letter for your unregistered trademark. Obviously, registered trademarks have more gravitas. Can you name a few IP professionals, particularly in relation to technology-based products? I can send you a list. We code Caribbean, and we would be able to commute with that offline here. Remember the original song by Nyla, it's 3 minutes, but the adaptation for Despers was 8. Who owns the adaptation, the arranger? We could get into that at a different time. You can always call the Intellectual Property Office for different information. I'm going to have to wrap up this, guys, so I'm just going to leave it there. There are a few more questions, but I think I've answered most of the questions. I'm going to go back into the presentation now, and I will try to answer, because we have another Q&A after I finish Madrid, so I'll try and answer those after I finish. So let us, barring technical difficulties again, share that. Okay, great. There we go. Great. Back into the Madrid Protocol. What is the Madrid Protocol? I can hear the clamor for all the people who knew everything that I've just spoken about, who are bored out of their minds, thinking, Kavish, when are you going to get to the point? Here we are. The Madrid Protocol is an international filing system. I want to make it clear that it is a filing system. It is not an international registration. Something is called an international registration under the Madrid Protocol, but that is a certification process, and it's called a registration, that says that your mark is being forwarded to a number of territories around the world. But it is not in of itself an international registration in the normal sense of the word. So I need to make that abundantly clear from the start. Yeah, it is an international filing system. So the Madrid system is, there's the Madrid agreement, which has now been frozen because it's a really old agreement, and you have the Madrid Protocol. What Trinidad and Tobago is a party to now, we just succeeded, and we will be implementing as of January 12th, is the Madrid Protocol. It's a very long name. I'm not going to bore you with the name. So moving swiftly along. You can get protection for your trademark in several countries around the world. Again, I need to make it clear, abundantly clear, that it's a filing system, and the trademarks are still subject to the registration process in those countries. So you would always have to think about your territories and where you're filing and what your trademark means in those territories. And we always give the example of Tata. Tata is a brilliant Indian company, brilliant brand. And for some reason, when they came to Trinidad, they were wondering why they weren't having a lot of traction and success. Well, it's because Tata in our local parlance means garbage. So if your brand is Tata, then it's Tata, and Trinidadians don't want Tata. They don't want to drive a car that's Tata. I'm just using that as a hyperbole, but that's the situation. So you want to think about what your brand means in the countries that you're going to, because you don't want your brand to be offensive. You don't want it to be against the country's public morality. You don't want that there's another well-known brand in that country, those kind of things, yeah? You are going to be subject to the rigors of that country. So just to explain Madrid Protocol in incredible detail, if you don't remember anything else, I think this slide is one of the most important slides that I will show. And this is straight out from WIPO 2020. We got this yesterday. And this shows all of the countries that are party to the Madrid Protocol in red. Yeah, 107 members covering 123 countries, because there are multiple regional bodies like EU, the European Union, and OAPI, Africa, a lot of African states there. As you can see, there's a tiny little circle around Trinidad and Tobago, little dot on the map. You know, maybe you can see it, maybe you can't, but there's a tiny little circle there and a tiny little circle for Antigua and Barbuda. And then there's also Cuba. So there are 3 Caribbean countries that are party. And, it's 80% of world trade. So most of our trading partners in Trinidad and Tobago are party. Talking about, you have some Central American countries, you have the US, you have Canada, you have African states, you have the whole of the European Union, you have Russia, Australia, New Zealand. You know, you have some South American countries like Brazil. So there are lots and lots of countries and lots of export and import markets that are party to Madrid Protocol. 123 countries. We are number 1, 2, 3. We are the 123rd country to join, making us the 107th member of the Madrid Protocol. It is something like 70% of the entire world population is covered by this. So your brand can reach 70% of the entire world population. That's the beauty of the Madrid Protocol. In 2020 to 2022, they're looking at other countries. So within the Caribbean region, Jamaica has expressed their interest. Costa Rica as well, I believe, is coming on board. There's the last country in Europe, which is Malta. Lots of other African countries, the Arab region like UAE and Saudi are coming on board. So it's going to expand. Sooner or later, it's going to be 90% of world trade covered by this. Yeah, and if not most, all of our trading partners as a country. Features of Madrid: you have one language that you'll file in. There are 3 languages to the protocols. You have Spanish, French, English. In Trinidad, we're using English. There's an examination time period of 18 months. There are fees for the specific countries. It is one fee, yes, but the one fee depends on the number of countries that you are designating, because WIPO, with the International Bureau, WIPO, is going to work with those countries. The International Bureau, WIPO, is the organization that is going to implement Madrid Protocol when it goes to designated contracting parties. I will explain all of that in detail coming up shortly. There are nations and regions, 10 years renewable indefinitely, so it's the same law of trademarks, and to have an international application through the Madrid Protocol, you need to have a basic registration, which means you need to have a pending application or registration in Trinidad and Tobago if you're using us as the Office of Origin. So if you are taking Trinidad and Tobago and saying, I want to file through Madrid Protocol and send it to WIPO that I can go to these multiple countries, US, Canada, China, India, yes, you need to have a basic application here. And you can take your registered mark as well, and you can file for an international application using your registered mark from Trinidad and Tobago. As Trinidad and Tobago as the Office of Origin, send it to WIPO and choose the countries that you want to designate. So the current system is called the Parish route. Parish Treaty, again, it was made in Paris. And then you have to apply in the specific jurisdictions. So you have to go to those jurisdictions. You have to get a local address for service through an agent. You have to file in the local language. You have to pay in the local currency. And it can become, if you are going into other countries, it can become expensive. And it can become cost prohibitive for many persons, especially SMEs. I'm sure exporTT is going to talk to us in a little bit about funding and stuff like that once Madrid comes on board. But this is the current position where you have to go to these multiple countries and you have to file individually in these countries through an agent. In the Madrid Protocol route, you can see that red line going from Trinidad to WIPO, International Bureau, WIPO in Geneva, and then Geneva sends it everywhere else. So there's a centralized system. It's a centralized filing process that helps with costs. It makes it better and more facilitative for persons, but it simplifies the process because you have one language, you're paying in one currency, yeah? So you're talking about multiple countries around the world through one application. And it's centralized for everything that you need to do as well. So in the Parish route, just to track, if you are renewing your trademark, for example, you have to go to those individual countries and file for your renewals in those individual countries. If we come to the Madrid route, you can file for the renewal at WIPO and it's renewed in all those countries, which is sensible for you. So you have your export market, let's say you're going to China and you're going to Brazil and you're going to the United States of America. So you can file your renewal through WIPO for those 3 jurisdictions and in Trinidad and Tobago, one system. It's just sensible and easy. Trinidad and Tobago, again, I said, 107th member, now covering 123 countries. You have regional routes, as in the French African countries, like through OAPI and the European Union, through the EUIPO. So they cover lots of countries in those regions. There are regional trademarks even through the Paris route that you can apply. So if you are going to Europe, you can apply for a European trademark. The actors in the Madrid system, we have the Office of Origin. The Office of Origin is the office where you are filing your international application. So you have to have an Office of Origin. You have to have an application or registration in a country that is party to the Madrid, and you want to file through that office Let's pretend it's Trinidad and Tobago. We want to file through that office to send the international application to WIPO. That's your office of origin. I hope that makes sense. It's where the application originates. Back to the common sense principle, office of origin. The International Bureau is the bureau that works with the international trademarks. Again, let the name speak for itself. The bureau that works at WIPO to facilitate the filing in a number of designated countries. Then you have the designated contracting parties, is the contracting parties to the Madrid Protocol that you are designating in your application. Let the name speak for itself. So I know that's a lot to take in there. You have the O, the IB, and the DCP, but that's your standard stuff when it comes to Madrid. So talk about your designations and where you want your trademark to go to, and that will be done through the International Bureau. Two roles of the IP office. The office of origin, if as Trinidad and Tobago, once we become party, if you come to us, we're going to assist you to file an international application. You can do it through an agent as well. We certify your application is ready as an international application to go to the International Bureau, and then we help you with any irregularities that may happen. The designated contracting party, once they receive your application from the International Bureau, they perform their substantive examination and they determine the scope of protection. As I said, you need to think about your markets to make sure that you are something that is registrable, that you're filing something that's registrable in those countries. You don't want to end up in a situation where you file something and it's not registrable in that country. There are ways to do searches. A lot of the larger jurisdictions and even countries with developing economies, like Trinidad and Tobago, we have websites which search facilities are available and can expose you to what is registered. So you want to look at your mark and you want to do some background searching beforehand. So the international application at the Office of Origin, you file it, it goes through formalities, we classify, and then we certify. So it's very similar to a local application. Again, there needs to be a local application, but this is a separate international application that you're making alongside your local application, and sets out basically the same sets of features that we'll have to go through for local applicants. Yeah, the role of the International Bureau now. So the IB, they examine the international application. They record the information on an international register. So they have this register, they publish all these marks that are being sent to designated contracting parties around the world, right? And then they notify the designated contracting parties or states or regions, hey, this person filed for this trademark from Trinidad and Tobago and has designated United States of America. Please examine this mark. Boom. And there's a time limit that they have to examine. Most countries go with an 18-month time limit. They have to examine your mark within 18 months or else it's automatically registered. It's a good thing for users if you don't hear back from the country, because it means an automatic registration from you. Yeah. So that information regarding the National Register goes up in a gazette. Processing of the application at the IB. So the IB, International Bureau, once the Office of Origin sends an international application to the International Bureau, they check through the formalities and the classification, they record the information, they notify, and then the countries communicate with the International Bureau, and then the International Bureau communicates with the designated contracting party and the applicant respectively. So the IB contacts the DCP, the designated contracting party. The DCP, the designated contracting party, does a search, make sure that all is on the up and up, and then boom, you examine the mark, and then you communicate us as the office here. If we were designated, we communicate with the International Bureau. Let's pretend there's a similar mark and the mark needs to be refused. We would communicate the refusal. Let's pretend that the mark is acceptable and goes on. Then we communicate that acceptance, and it goes through the same normal process. Yeah. So what are the advantages of the Madrid Protocol? Everyone is saying, yeah, Kavish, thank you for the process, but I need to know how this is going to help me. Well, it's very convenient. It's one application that can take you into 123 countries. So think about that. One application, 123 countries, brilliant. It's one currency. So you're paying in Swiss francs. We do everything in US dollars, which is great for us because we asked for that from WIPO. And there's one language. For us, it would be English. There are 3 languages of the protocol, so it's French, English, and Spanish. But we are using English because we're an English-speaking country. I believe that Spanish is our second language now, one of our official second languages, but we haven't implemented Spanish yet as a working language in the office because, well, people need to know Spanish in order to implement it. Sí hablo español, but not everyone speaks Spanish in the office. So we're not going to do Spanish yet because then Kavish might have too much work to do. We have global trademark. This is another benefit. You can get registrations in multiple countries covering 80% of world trade and 70% of the world population. Gives you a competitive advantage that you have this registration process that is simplified, where you can go into your specific markets that you need to go into, that you want to go into, that you're operating into, that may have been cost prohibitive in the past or may have been too difficult or too daunting for you. There is this process that the office here will help and walk you through. Again, you can have agents. Agents are already willing and able to lend their assistance in this regard, who can help you file. It is cost effective to go into the other jurisdictions. While it might be the same price to file for your local application, when it comes to the international application, again, you would have to go through the Parish route, and the Parish route can be cost prohibitive at times. So the cost effectiveness cannot be understated. The fees under the Madrid. So I know that a lot of you are going to say, okay, you've been talking a lot, good information. What are the fees? I need to know how much it costs. I can't answer that question because how much it costs depends on the number of countries that you are designating and the fees in those countries. So there are 2 sets of fees. There are basic fees and there are individual fees. So a country can choose, okay, we're not going to go with Wipo fees, we're going to do our own fees, and the equivalent of our own fees. Quite often it works out less than the basic fees. There's Wipo's basic fee that you have to pay to process the international application, but the application needs to go into those countries. So if someone is filing an international application and designates Trinidad, they would pay an individual fee of however much, depending on the classes in Trinidad and Tobago. There is a fee calculator available on the Madrid Wipo site. You can go up and you can literally say, I want to file in X jurisdictions, tick off your boxes and see how much it will cost. And I know exporTT is coming up with brilliant ways to help our exporters and our importers and our SMEs and our businesses in Trinidad and Tobago to make this more cost effective for them. So please feel free to use the calculator. Nothing is binding you when you come up with a fee in the calculator, just in case you were wondering. You don't have to enter your credit card information. Right? There are multiple modes of communication. Modes of communication in Trinidad and Tobago will be electronic. The International Bureau is working electronically for the most part, if not for the entirety of what they're doing. They propose to continue working electronically, especially in the midst of a pandemic. So communication will be electronic. You would converse with us electronically. If we can set up virtual meetings if need be, especially again during the pandemic, we want most everything to be virtual. We would have that facility available, and the IB, we communicate with them virtually as well. Right? There are lots of online tools. The Madrid Goods and Services Manager is already available on our website, so you can classify your goods and services there. The office portal is for us, so that's how we communicate with the International Bureau. You as an applicant using the international system of the Madrid Protocol, you would have a Madrid monitor. So it's a gateway to use the system. You can update your trademark, update your information, those kind of things. There's a portfolio manager, again, that is for the private user, the applicant, to converse with the IB, look at the history of your mark, related documents. Let's pretend some jurisdictions require use of a mark, like the United States. You would have to get use to prove that the mark has a real and commercial effective trade in their country. So yes, you have your Madrid portfolio manager that can help you with those things. You can always converse with the International Bureau. Yeah. Just some quick statistics. There in 2019, there were 64,000 international applications at the International Bureau, and which represented 430,000 times that the 122 countries at that time, 122 countries were designated, because we aren't designated yet until January 12th. L'Oreal, it's interesting that the top brands in the world are for the top 10, a lot of tech companies. L'Oreal is the #1 top filer using the Madrid system, followed by Novartis and Huawei. This is 2020 statistics from WIPO. And if you can look at this, the filing origin represents a lot of Trinidad's trading presence and markets. So US being the top one, and you have lots of European countries like Germany, France, Switzerland, UK. You have China. So there are lots and lots of countries here that represent our import and export markets, that represent our trading partners, and they are now provided the opportunity to expand their markets in Trinidad and Tobago in a simplified, cost-effective procedure. So go through some quick case studies. Microsoft has said that, and just on a side note, Microsoft is worth $162.9 billion. Just the brand. This is just the brand. This has nothing to do with the other assets. Just like the Apple brand is worth $241 billion, the Microsoft brand is worth $162 billion. And they've said that their cost for filing international trademarks around the world, international filing of trademarks, has gone up by 40%. So their whole thing is cost effectiveness and simplicity. Nestle has thousands of brands, and they use it because it's cost effective, it's easy to administrate, and they encourage all companies to use the Madrid system. It also helps with the modification of your trademarks. You can make centralized changes, you can make updates. So let's pretend you wanted to do a renewal. Let's pretend you wanted to change your name, change your address, change your ownership. You wanted to assign the mark, you wanted to add a license, you wanted to sell the mark completely and get it over with, which would be an assignment. Things like that. You can restrict the scope of your goods. You can do in a centralized way via the centralized system. Yeah, that's the benefit of Madrid. In Trinidad and Tobago, we have lots of international and national strategies. We are working with WIPO right now to come up with greater national strategies. We're working on some international platforms as well to inform the world that we are party to Madrid. So for local, we have a MOU, a pending MOU with exporTT, our national sporting body. exporTT, if you're there, shout out to you, for athletes or sports persons, people involved in the sporting arena. Like DJ Bravo's trademark is registered in Trinidad and Tobago. Now he can file in multiple countries. So if he playing wherever, he playing in India, he playing in whatever other country he'll be playing in, boom, he can file for his trademark there through the Madrid system. Keyshawn Walcott's name is registered in Trinidad and Tobago. Perhaps he wants to register in another country that he's going to play some big event at, Javelin Master himself, he can use that. We're going to talk about our creative sector. We're going to propose an MOU with exporTT for artists and the creative sector. So we have Marshall Montano and his Double M. And you think, wow, okay, right. Marshall Montano is doing things even outside of his normal music. There's Montano's chocolate. Perhaps Marshall wants to export Montano chocolate, because everyone knows that, Trinidad and Tobago cocoa and chocolate is some of the best in the world. It really is some of the best in the world. Perhaps Marshall Montano wants to go into other territories with his chocolate. You can use the system. Show in, yes, of course. Same thing. If he wants to go into other markets, he wants to expand horizons, go into an export market, yes, you can use the Madrid system for that. This here, right now, because of what the controller, myself, and the CDC TTL, the Cocoa Development Company of Trinidad and Tobago Limited, have done is now one of the most powerful certification marks in the world, because Angostura cocoa bitters is using certified cocoa from the CDC TTL, and you can see that certification right there on the left bottom side. It says certified there. They're using certified cocoa. They're a certification body. They certify cocoa that comes to them. If you are a cocoa farmer and you are looking to get certified with the CDC TTL, please contact them, contact us. We would help you along the process, help you get in line with their certification process. But now that they have partnered with Angostura, they are some of the most powerful brands in the world. That small certification mark that you see on the cocoa bitters is now one of the greatest brands in the world. And again, thanks to Angostura. Angostura is in over 100 countries, one of the most powerful brands in the world as well. Talk about our SMEs. This is a great project that's happening now, the Moruga Hill rice. They have actually applied for what is called Wipo match. So they're going to be matched, and they have been matched. It happened recently. They have been matched with an investor who's going to help them come up with their commercial platform to commercialize their rice in other markets. So they started off as a very small business, and now, boom, they are blowing up. Moruga Hill rice. It tastes great. Check them out. There's a proposal for them to probably have a GI. We'll work with them if that's what you want to do. If you're listening in, Moruga Hill Rice Corporation, we said, oh, we want to work with you. Come talk to us. You know, we here. You know, Madrid and trade. Just as we finalize now, Madrid represents 80% of world trade. Lots of our trading partners are party to Madrid Protocol: US, Canada, EU, China. You know, they're working on Latin American countries, but Colombia, Cuba. One of the biggest markets now is Cuba. If I'm not mistaken, when it comes to cosmetics, Cuba is huge. Sasha, feel free to correct me if I'm wrong, but Sasha has been exporting to Cuba, and there's a huge market in Cuba for cosmetics. We look at the trade agreements and our FTAs, you know, and our partial scope agreements. We're looking to Madrid for the ease of doing business. So these are from the Ministry of Trade directly. They tell us about all our bilateral and trade agreements. So we have the Caribbean Basin Initiative, which is the US. Venezuela is not yet a party. So you look at Costa Rica is not yet a party. They're working on it, is what we were told by WIPO. We have the partial scope agreement. We have the EPA, the Economic Partnership Agreement with the EU. That's being finalized with Chile. Chile has also said, yeah, we want to look into Madrid. So lots of countries are coming on board. And these countries, we have partnership agreements with. So our trade can expand in ways that we never thought before. Think about our non-energy exports by region. North America is 51%. Again, Ministry of Trade provided these stats. 51%. And North America are party to Madrid. So if you're looking at our non-energy exports and you're exporting something like food, goods, whatever you're exporting, Ministry of Trade is telling you, hey, North America is a huge market. And we're also telling you, hey, Madrid Protocol is a way to get your brand in there, to register your brand. You know, if you look at North America, you have what, $6 billion worth. Caribbean has 4.9. We're going to encourage other Caribbean countries to join. Jamaica, again, has expressed their intent. You have Asian countries, Central American, European countries. So Madrid Protocol is going to offer benefit in ways not just for our athletes, not just for our creative sector, not just for exporters, not just for SMEs, but for our country as a whole to benefit. So in essence and in conclusion, points to remember. Yes, anytime you go to Tobago, you remember Pigeon Point. That is Pigeon Point. Gorgeous place. Someone asked me yesterday, how is Pigeon Point so clean? Great question there. I'll leave that right there. Register your IP. Madrid Protocol is coming soon. We have a final poll question, survey question by Gavin. Gavin, if you would put up that final survey question for us now. So, do you believe that the Madrid Protocol will be beneficial? It's yes, no, maybe, and well, of course it will be. What took so long? Just to answer the question in advance, it's not an easy process to engage WIPO in terms of registering accession documents and drafting legislation and getting stakeholder consultations done. It is grinding, it is painstaking. I have been part of this process for a long time now. And so we have ground support for yes, and of course it will be. No one has said no. People have said maybe. For all you maybes, you know, Johnny Bravo once said maybe it's just a baby. Well, he didn't actually say it, but it wasn't Johnny Bravo. Maybe it's just a baby that needs tender love until it turns into a yes. So if you want to come talk to the IPO, we would help you. Talk to your agent, they will help you, and we can help you get on board with Madrid Protocol. What took so long? Hey, let the past be past, right, Judy? Past is the past. We are going forward January 12th, people. January 12th is where it's at. Feel free to catch us on Instagram, Facebook, Twitter. I have left my email address up there. Mr. Ramlal is the head of education as well, Lalo Ramlal at ipo.gov.tt. Feel free to email him as well. You can call us 2264-IPO 4476. I prefer you call Judy. Judy, you'll call you, right?
Hello. Yes. Well,
so I'm going to stop sharing now, and I'm going to go through all. I'm sure there are a plethora of questions. It is 11 o'clock, and I know we said we're going from 9 to 11, so I won't take too much time answering many questions.
Fortunately, Reagan did a lot of the responses for you, so if you glimpse.
He did a lot of the responses. He has the interests of the office at heart always.
Yes, he does.
So I don't know which ones he answered, but can you walk me through which ones he didn't answer, Judy, and I can answer them?
Okay, we have here people primarily telling you well done, brilliant job, thanks for hosting this event. After the questions were answered, we have one question. We'll be receiving a copy of the recording. So I think, thanks exporTT. It's a great presentation, Kavish.
Oh, very good answer. Yes, you can.
Lots to process. Thank you, exporTT and Kavish. Loved your delivery. Just loads of support.
Not to cut you across, but I saw a question from Adi that said, reading up on the local IP battle with Japs and Darrells. Do you think a dispute resolution clause in your contracts is a good idea? Yes, always. I'm pretty sure that every well-crafted contract has a dispute resolution clause. And usually, again, don't take a cookie cutter necessarily, but usually it says something like, or we have mediation and then we have arbitration. So yes, it is a good idea. That is not specific to Japs and Darrells. That case is, if I'm not mistaken, still before the courts and still before the Court of Appeal. So it stands to be corrected on that, but it's still before the Court of Appeal. So I am not going to comment on that. In the same way that I'm not going to comment, someone asked about KES. I'm not going to comment about that because we can't comment on ongoing things. So I won't comment on that. Chrisanne is here. Chrisanne, if you want to take over, and then at the very end, if people want to stick around and hear me answer the rest of the questions, I'm willing to do that. But Chrisanne, please feel free.
All right, thank you very much. It will be impossible to follow up on that presentation that you did and still keep everyone's attention. I see we have like 100 of us here this morning. Thank you all for sharing your morning with us. So I'm going to present very briefly on the exciting things like what Kavish spoke about. I'm going to talk a little bit about the financial support that we could offer at exporTT. So let me just go ahead and share this screen and we'll get into it. This will just be a few minutes and we'll take some questions. All right, so at exporTT, we offer different types of funding and facilities. I'm just going to talk about two this morning. So we have the co-financing facility. What this is we try to offset the costs of certain export-related activities that companies will have to face when entering export markets. So we can reimburse or, well, help you fund 50% of the cost of certain things, such as product testing, shipping of samples, trade show participation. You need to modify your label to meet the criteria to sit on shelves in international markets. We help with that kind of stuff with co-financing. But as is applicable to today's presentation, we also co-finance company registration in overseas markets, well, brand and company registration in overseas markets, as well as intellectual property registration in overseas markets. So the costs that Kavish spoke about earlier are related to filing under the Madrid Protocol, as well as securing your trademark, your copyrights, and any intellectual property that you want to have secured and have proper ownership of before you enter those export markets. We can help you with co-financing. So it's 50% of these costs and there are limits to it. So for small companies, the limit for co-financing is 50% to a limit of 35,000 TT per year. When we say per year, we talk about per fiscal year, and our fiscal starts in October. So small companies can access 50% to a limit of 35,000 for everything that's covered under co-financing, including securing the intellectual property. Medium companies can access 45,000 as their limit annually, and large companies who generate over 15 million can access 60,000 in co-financing for some of these activities, because the larger companies with bigger product lines might face some additional costs given the size of their production and the amount of products that they'll need to register or move to international markets. So that's the co-financing. We have the research and development facility. So the purpose of this is to stimulate investment in innovation as well as new technology that companies should employ in creating their products, creating new products, diversifying their products or processes as they go forward. And I say products, this is actually products and services. Both of these grant fundings, they cover products and services. So the RDF, you can apply for either phase 1 or phase 2 that you'll see on your screen. Phase 1 is to establish technical merit. So this is like a feasibility study. Companies can access 70% of that cost to a limit of 100,000. The phase 2 is for the actual new product or service development, and companies can access 50% to a limit of 750,000. Now these costs don't include things like infrastructure or equipment. There are other grants for that. But the research and development facility, this is for the technical costs to get that new product or service done to the point of a prototype, proof of concept that you can then take to market. Now within this phase 2 that you could apply for right off the bat, it also includes securing intellectual property and ownership of the new product and service. And this is something that companies should be very cognizant of. Don't go and advertise your new products and services if you know that you don't have, you didn't secure proper intellectual property for it. Because the IPO and Kavish might be able to speak to this. If you take that into the public domain, you're pretty much just letting go your ownership of it. So when you're applying for the grant fund, for the research and development facility, be aware that we can, in that overall project, help you secure the intellectual property for this new creation as well. The phase 3 is for commercialization. So you can't apply for phase 3 without firstly having been a recipient of a phase 2. Phase 3 is for commercialization of that new product or service that was created in phase 2. And what I'll do is I will just show you all how to navigate the website to get this done, because the first step is sending an application. So you go to exporttt.co.tt. Let's hope this works. Right. So when you enter exporTT's website, enter the site there. You go into export resources. You'll see a series of drop-down menus on the top of the screen here. You go to export resources, financing facilities, and you'll see further drop-downs for RDF and co-financing. Like I said, there are other grants as well, but this morning we're just talking about the RDF and the co-financing because these are the ones that can be most impactful on your intellectual property. So for the RDF, it's quite simple. Once you navigate there, you scroll to the bottom of the page, you'll get additional information on the RDF. You scroll to the bottom of the page and you'll find the application form there at the underneath. Similarly, with the co-financing, it's the same kind of navigation. So you go to the export resources, financing facilities, co-financing, and there is the application to the bottom of the screen. It's in red, so people often miss that. It's right there. It is in fact a button that's the same color as the bar. All right, so that's the first step on how you go about doing it. A little bit about how it works. So for co-financing, you cannot apply after the fact. If you're successful for co-financing, exporTT will sign a contract with you saying, okay, we commit to covering this amount of costs based on projected expenditure. And you will have your quotations to back that up. So unfortunately, we cannot apply co-financing to something that you already spent. What I'm saying is before you spend anything at all on this activity, send in your application with exporTT, give us a call, I'll provide some contact info. Let us know that you are going to spend this and let's do this application before the fact, all right? Because we cannot, and I know right now some of you are probably thinking, wait, I did something, I should probably get that reimbursed. Unfortunately, this is not the case. And every time I give one of these presentations, that's a question that comes up. So I just want to answer that up front. Let us know up front and send in the application before you expend anything on this project. Similarly with the RDF. So the co-financing is evaluated by an internal committee here at exporTT. The RDF goes out to a 4-member committee that's chaired by exporTT and also comprises members of the Ministry of Trade, Ministry of Finance, and Exim Bank. Sorry, Ministry of Planning. Exim Bank is for another grant. So that is the process. But what I really want to get across in these few minutes here is please send in your applications before you spend anything. There is a facility here to help you. Actually, there are several funding options to assist you with this activity. You will get my contact info. So let me just get out of here. Right, one other thing I want to touch on this morning very briefly is something that is in development. So we spoke about the RDF and the purpose of the RDF. Something that we proposed to the Ministry of Trade and is in the works right now, but I can't really speak to it much right now, is the proposal of the innovation vouchers. So we are trying to get something in place where we can get innovation vouchers, where companies can use that to access any technical expertise that they need to instill more innovation within their company. This is not just new product development. This could be changes made to your export market. And I want to reiterate that everything we do at exporTT is export oriented. So everything you have to prove that it is to increase your ability to export. So we will speak in the upcoming months about the innovation vouchers, depending on the level of approval, but I just want to let you all know upfront that we have something in the works for that. And we're proposing that small companies can access up to 200,000 in vouchers, 100% of 200,000, medium companies 70%, large companies, medium companies 80, large companies 70%. And the reason is we want SMEs to focus a bit more on innovation, and we'll give the additional support for that. So that is my brief presentation this morning. I'll take some questions. This is my contact info, so you can contact for any additional information. If you can't get through to my phone, feel free to leave WhatsApps on my mobile number that you'll see there. We will share this brief presentation with you, but there's also a lot more information that I could share on different types of grant. So thank you for your time, for a few minutes, and thanks for sharing your morning with us.
Christian, I just want to say that this these vouchers and the strategies that exporTT is putting in place are brilliant. And I think it's going to be very helpful for our SMEs in Trinidad and Tobago to grow and grow and grow. And even the larger companies to expand their horizons to places that they've never thought before. So I'm glad exporTT is doing what you're doing, and the strategies that you have put in place are phenomenal.
Thanks, Kavish. And we really hope to see some uptake this year with the companies. And feel free, Kavish. We usually get referrals from the IPO. You feel free to send to me. All
referrals.
Right?
You
Yes.
see? Right? I call in Judy, call in Kristen,
Good.
Gavin, is everybody getting phone calls right through.
Try before 12 now.
12 minutes, okay, no problem.
All right. So do we have questions, Judy? Do we entertain any questions?
There are a couple of questions that I didn't get to, if I could be allowed to answer them quickly. 10 minutes, maybe?
Mm-hmm.
Yeah, Judy, is that okay with you?
Yeah, sure. Once our participants are in agreement, I am sure they would love to listen to the. I think about 3 or 4 you have outstanding.
I think a lot of people might be tired of hearing my voice, but that being said, on to it. So they said with regard, Chris Brooks, I saw this question. It's a great question. That's why I kind of said, let me track back here. With regard to registration, what if you're operating in multiple jurisdictions via online means YouTube? Do you then need to register your trademark in jurisdictions where there are viewers like USA, UK, Canada? And I want to say yes. Trademarks are also online. There's entirely new jurisprudence within the last 10 years for trademarks and the online presence that trademarks have. So yes, if you are doing it, if you have a specific market that you see is gaining traction, like there are a lot of Asian markets that look at random YouTube videos or Facebook videos, and you may be a company that puts all those things. You may be a tech company that creates memes, or you create GIFs or whatever you do, and you see that countries are tracking with it. You may want to look for protection in those countries. So yes, think about the online realm as well. It's not just where you are exporting physical things or where you are importing physical things from. Yeah, that makes sense. Spoke about JAPs. I have Kavish Seetahal. Shout out to Kanta Singh or Sakrikita. Given that you have a trademark registered and associated company, what restricts other entities from stealing IP and ideas and business strategies, right? And I don't want to belabor this, but for IP disputes, there is a Wipo ADR center, our Alternative Dispute Resolution Center. We have actually negotiated some of the lowest fees in the world for this ADR center. So it's really beneficial. You can find that information on our site. Just look up ADR on our site and you can see, oh, wow, okay, there's this ADR center. If I want to make the IP professionals from around the world, thousands and thousands of IP professionals around the world. So if you think about that, what stops someone from stealing something? Well, the law. I know that sounds probably a little simplistic, but yeah, it's the law. You're not allowed to steal someone's brand. It's property. In the same way that you're not allowed to steal someone's car. It doesn't stop thieves from doing it, but the law is law, right? So I would say it would be beneficial if you chase up your IP, make sure and register your IP so that it's easier to stop people from stealing. And you know what? I don't want to sound like I'm encouraging it. I'm in no way encouraging breach of the law. But I'm in no way encouraging breach of the law. When someone steals your brand, it means that your brand has quality that they see that they want to steal, which in some way can flatter you as a business. Stop them with the law, please. You don't want people stealing your brand. But when people do steal your brand, you think, oh, okay, company making it. That's maybe a good sign, you know? So think about that. Think about protecting yourself. Think about protecting your IP. We are pushing for an enforcement unit as well in Trinidad and Tobago. And we have Building Respect for IP division works for WIPO. So it's huge in that regard. Yeah.
Kavish, if it's okay, I want to answer one question I'm seeing.
Yeah, go through.
All right. So it's actually not intellectual property related at all, but it's an interesting question. It's a question that comes up often for us. So now that we have the forum here, I can probably share it with everyone. KC Candy asked, how did COVID affect export this year? So what we've seen so far is generally it has negatively affected exports. However, we have seen companies, and this is dependent on what you export. We have seen companies actually thrive in COVID. Companies who do the health foods and the special ingredients to cook at home have actually seen increases during COVID. Things like all these various superfoods and super ingredients, they actually have been better than they've ever done before under COVID. I think it's because of the fact that a lot of people are focusing on their health right now, as well as consuming at home. So we also see companies who sell products that traditionally their main their source of income was from restaurants. We actually see that they push more product to consume at home, talking about things like juices, even beer. And we've seen them increase sales over the COVID period. So it isn't all doom and gloom. It isn't all negative. It just depends on what you sell and how you sell. You need to get yourself online and you need to push your B2C sales. And we provide that support at exporTT as well for your website development as well as your e-commerce functionality. So that's my take on answering that question. Overall, it has been negative, but not for everyone. And there are ways to pivot and thrive during this pandemic. Thanks.
If I can add to what you said, Christian, a lot of tech companies and telecommunication companies have seen themselves on the rise. You know, they have expanded exponentially. For example, I see a lot of new hosting services for virtual meetings and virtual classrooms and things like that. So you just have to, in these times, you have to think outside the box, figure out ways to get your business online, figure out ways to expand your business into a world where you're not necessarily completely affected by the pandemic, but you innovate to a point where you can overcome the pandemic from a business standpoint. Yeah. I saw some other questions. There were a couple of great questions here. Zaria asked, can you recommend various options when it comes to paying for your design of a trademark? When you're talking about paying for design, Zaria, I presume you're talking about when your graphic designer is designing a trademark, or I'm not entirely sure if that's what it is. That's between you and your independent contractor. When it comes to paying for a trademark here, you can pay by a check, you can pay via links, or you can pay in cash in the treasury. It's one of the lesser pushed versions of payment. And you can pay online now. There's electronic payment via credit card, and hopefully soon via debit card. So there are multiple ways to pay the office here, right? I saw Christine had a question about the music festival, which the boss, Mr. Regan Asgarali, in case you don't know, Regan Asgarali is the boss, the controller of the Intellectual Property Office. And the music festival, great answer. Well, I mean, I don't want to tell the boss the answer, a great answer. He's the boss. But Christine, please come and talk to us and we can have a conversation about the music festival, yeah? Nikisha, you asked, can you have 2 trademarks? Yes, you can have multiple trademarks, as many as you want, as many as your money would prohibit and your business plan. Proposed fees for filing, our current fees are up on our website, Akila, so you can go table of fees and you'll find all our fees there. Does the automatic registration after 18 months apply here in Trinidad and Tobago? Yes. We gave a declaration upon accession to the Madrid Protocol that we will be...
Bcash? As a Bcash, Lord.
Judy? Okay, sorry about that. The automatic registration, yes, it applies after 18 months in Trinidad and Tobago as well, but we were examining way before that time. Great presentation. Okay, thank you, Akila. I think I answered most of the questions. In terms of ADR, the boss had a webinar with Dialogue Solutions, a local company, and WIPO regarding ADR and the use of the Wipo ADR Center. Suffice it to say, it went great, and the ADR Center is fully available. There are local consultants as well, local professionals who are IP professionals in the field who can help you resolve the dispute. There's the National ADR Center as well, through the court system that you could go and get mediation done and things like that. The Wipo Center is for IP disputes, so that's sort of specific to IP, but there are other ADR centers you can go to. Right, I think I answered all the questions that have been posted. If I missed your question, email me the question. I will answer you. You can email the office. You can set up a meeting with the office. Yeah. Oh wow, there's 23 new messages. Sorry. So Dion McNichol Stevenson. Dion, good to hear from you. Hema, thank you. Mariana, thank you. Last question. Mentioned was 3 Caribbean members: Antigua, Barbuda, Cuba, and so it's Antigua, Barbuda, Cuba, Trinidad. That's it right now. Who's to say within the next year there may be 10 others, there may be 5 others. Again, the process is not a simplistic one. The process for registration, for accession is heavily involved legislatively. It takes a lot of planning, takes a lot of working with lots of ministries like the Ministry of Foreign and CARICOM Affairs. Shout out to MFCA because they helped us a lot when it came to accession stuff. So who's to say? I can't say. I don't work for the IPOs there, but feel free to contact them. Yeah, so does Andre, I think, had a question for Kristen. Oh, well, sorry. Well, maybe it's for me. Does certified CARICOM nationals have access to the same type of registration as Trinidadian nationals? But it would be Trinidad and Tobago nationals who, well, if you have a real and effective, so one of the requirements under Madrid is a real and effective commercial presence. Once you have a really effective commercial presence here, which would mean you would have a business registration, company registration, those kind of things, then you can possibly access the Madrid Protocol. Yeah, does that make sense? I hope that makes sense, because that's how the Madrid Protocol works in terms of filing in the Office of Origin. I could go into, we would have other sessions. This would be one of a couple of sessions we will be doing with exporTT, and hopefully sportsTT and creativeTT in the near future. Coming into early 2021, we will have multiple sessions, and we will get deeper into how to file, what are the filing requirements, what does the form look like, how to fill out the form, those kind of things. We will go into that, so stay tuned. Yeah, Judy, back over to you. With one more question from Akila. Akila, you've asked a lot of questions. So Akila has been paying attention. Thanks, Akila. One more question. What are the online payments for trademarks deducted in the US? What? One more question. Are the online payments for trademarks deducted in the US? I believe you said that. I want to confirm. I'm not necessarily sure as to what you mean, Akila. We are working with WIPO for all payments to be made in US as opposed to Swiss francs. Swiss francs is the currency of WIPO because they're in Geneva. But in terms of working with WIPO, you want to make that US because we have access to US dollars. So it's simple in that regard. So in terms of using your credit card, it would be US dollars, Akila. Yes? No, don't apologize for the questions, Akila. Akila, no need to apologize. That's why we're here. That's why we're answering the questions. It is 11:30. I've taken up way too much of your time and attention span. Hopefully I had your attention span. Over to you, Judy.
Oh, let me see if I can unmute now. Yes, Kavish, both you and Kristen have engaged our participants to the end and held their interest. I don't know how to thank you both, but I'm sure they would have learned a lot from this insightful, engaging workshop. And at this time, I would like participants to look into their inbox, check for the surveys so that we can share it with the IPO office and our exporTT management. Well, from the information I've been gathering from the chat, it says volumes, Kavish and Kristen. So I want to thank everybody for staying with us until the end, and be safe, be productive, and have a good day.
Bye, everyone, and thank you. Feel free to contact us, and we would get in touch with you ASAP. Nigel says the meeting needs a meetup. Nigel, I'm not sure that's possible in COVID, especially with 100 people in the room. But yes, when we all have some herd immunity from vaccines, perhaps at that time, but not at this juncture.
So Kavish, let's remind our participants that the persons who would have wanted to have one-on-one meetings, again, we'll have to do those things virtually at a time convenient to both the IPO office and yourselves. So be safe, and thank you once again, everyone. Thank you, Kavish.
Yes. All right. I'll stay on for a little longer while everyone leaves, just in case anyone had any questions. I want to also plug that we did a couple things with we had an entrepreneurship seminar a few months ago, and we did something for sports as well, because we want to really push the innovators of apps and technology-based companies, because technology is where the most valuable assets and the most up-and-coming in terms of monetary companies, in terms of monetization of their assets and stuff like that, the most up-and-coming companies are all technology companies, even on Kickstarter and things like that. So we did an entrepreneurship thing. You can also look into what is called patent mining. And we have a patent mining seminar coming up, right, Judy?
Yes, I told them in the chat, November the 26th. Next week,
right.
Thursday.
So in case you want to know what patent mining is, I'm not going to say anything about it, so that you have to come, be prepared. Google it beforehand so that you can have a good understanding of what's going on. Contact information will be sent. Ashley Jardine from ANSA, thank you for being there. ANSA, I know, has been clamoring vociferously for the Madrid Protocols for, I want to say, a few years now, and they have been very instructive in helping us from that perspective and pushing us to make sure it's done. So Ashley, good to hear from you, and I look forward to ANSA being part of this protocol. Ease of doing business. Ease of doing business. Nigel Devines had said something that was interesting to you know. Nigel Devines.
He says it sounds intriguing, the patent mining.
He said the meeting, this Nigel who said the meeting needs a meetup. Nigel, boy, I ain't sure right now, you know. Virtual meetups is where it's at, boy.
Mm-hmm.
Yeah. Patent mining sounds very intriguing. Yes, it really is. It's a way for companies to access things that you may not have access to otherwise. So, yes. January 12th is coming.
Margaret.
Yeah, I really want to say thank you to exporTT. exporTT, this has been fantastic. The turnout has been fantastic.
So Kavish, encourage them to fill out the survey.
Yes, I want to say, take it from me. I don't like filling out surveys. And I have lots and lots of surveys too. Every time we do something with WIPO, which is UN, you have a survey to fill out. And it's always, oh my God, a survey. But surveys really, truly do help the organizers of the meeting. It really do help us in terms of planning other meetings, benefiting our participants going forward, benefiting the users of the system. So please fill out a survey. We would love to hear from you. Love to find out what you guys think about what's happening. If you have some choice words for me because I talk too much, then please feel free to add that to the survey. I'm not sure I want to add that to the survey. Nikila is asking how they can register for the patent mining workshop. Judy?
Okay, what I told Nikila is I'll send the flyer, just send me the contact information. I sent her private my email address. But basically, it's a website on exporTT's website. It's on the IPO's website as well. So you have many ways of registering.
Yes, I agree. Dion said she just completed the survey. See, Dion is the boss. If you're thinking about anything copyrights, Dion is the person to go to, you know. I know Dion personally, so maybe a bit biased towards Dion, but Nigel wants to know if you're sending something via email, Judy.
Is it I will send to all participants the flyer as I did the survey, so that you have the opportunity to click and register. So that
great stuff.
Committed.
Great stuff.
It's in your survey actually attached. It's in the survey. There's an attachment. You open the PDF attachment and click register. So you already have it in your survey email. Thought about it.
Right. And if any of you at this very end, if you want to ask any questions in person, well, when I say in person, virtually now, please feel free while I'm on for the night. You're getting 5 more minutes of my time. I planned from 9 to 12 for this. It's 11:39. So if you really want, perhaps the administrators can give you some access and you can ask us any questions. But I don't think there are any. I think we did everything that we can. Feel free to contact us, and have a good day. Stay safe, stay sanitized, and think about persons who may have comorbidities. Think about them first. Protect the elderly, protect those who may not be as healthy. Go forward.
Give thanks.
What is a website to register a trademark? Peter. It's our website that you could go and you can fill out a registration form. But you would have to create a Wipo file account. We didn't get to go through that today. We were a little strapped for time. But there would be a follow-up session on how to file, what to do, things like that. So you can send us an email with your name and an email that you want to attach to the account. You send it to info@ipo.gov.tt, and you can send us a request to create a Wipo file account. Wipo file account is just the name of the system. It is an account to file online in Trinidad and Tobago at the Intellectual Property Office. So once you do that, we can get to your application process, and we can help you file online, fill out a form. Tip, 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 tip. All right, I think that's it. Have a good day, everyone. Signing off, and I look forward to the flurry of emails that are going to be in my inbox.